So, I mean, I think it's a fantastic decision. Judge Contreras he litigated these cases or supervised people litigating these cases for a number of years. DC is the hotbed of APA litigation and that regulatory fight that goes on. How can this case help other litigators in the immigration bar? Or if it's narrow, what did you take away from the case that you want to share with the immigration bar and people that may be faced with really complex litigation cases, especially business immigration cases? What, from your perspective, was your takeaway?
Read the regulations and the policy memos and the statutes really carefully. I mean, and even separately from the case law, I have to say that, there's a lot of case law that I pulled up and that I wove into the arguments that I made. But I think that one of the things that struck me, and it was not early on in the case, but that struck me was that, and was a point that I made to the court, was that the policy memo from 2005 about the question of what does USCIS do regarding the pending I-140 petition when the 45 is for 180 days is actually incorporated a little bit indirectly, but it is incorporated into the AC-21 regulation of 245.25. And it's not necessarily the most obvious thing, but it is there, and Judge Contreras does quote from that portion of the regulation. And so I think it's worthwhile, even in the more challenging cases, to take a step back and think about it differently. I mean, I had a couple of clients approach me about an H-1B case and pursuing litigation because they, in the master's cap issue, where they've been told by USCIS after all these years that, you've not been counted against the cap. And typically, I think we look at the H-1B petition as something that is just the petitioner's petition, and they're the only interested party. But if you think about it, they're in that particular situation, there's a clearly defined.
It's huge for them.
Yeah, I mean, they have a clearly defined interest that, in some sense, is even greater than the petitioners, because are they counted against that?
They can work for multiple employers,
exactly,
right?
Exactly. So I think it's definitely worthwhile sort of turning around what you have, looking at it from different perspectives, and see how things combine together. I mean, you may be able to come up with something that nobody has ever thought of. And the fact that nobody has ever thought of the argument just means that nobody's ever thought of it. It doesn't mean that it's a bad argument or, that not the right argument.